Hi, my name is Dominic Alford. I am a 1L student at Stetson University College of Law, and this is my contract project on Meg Thee Stallion and her ongoing contract dispute with 1501 Certified Entertainment. So let's get into the details of that. Who is Meg Thee Stallion? Meg Thee Stallion is a Houston rapper. She quickly rose to fame through social media, through her mixtapes, and quickly became one of the best starlets in hip hop currently. She won 3 Grammys, two of which were with my favorite artist, Beyonce. And she's asserting that the conditions of her deals was unknown at the time, and because she didn't negotiate that deal, she had no idea what was going on in it, and we're going to get into it. Also, she is a soon to be graduate at Texas Southern University, which is an HBCU, and she's going to be graduating with honors this year. So I'm really looking forward to getting into this dispute with her label. So let's talk about T. Ferris. T. Ferris is the person who helped broker the deal between Meg Thee Stallion and her mother and 1501 Certified Entertainment, which is who he worked for at the time. Carl Crawford, a lot of people know him. He was a baseball star. He actually played for us down here in Tampa Bay. He is the founder of 1501 Entertainment. He is the person who runs the label, who started the label, and who is currently the main defendant in this contract dispute. And then we have Jay Prince. Jay Prince is a music exec and well-known strong arm, quote unquote, in the music industry. To put it plainly, he is the person that you call to come in and threaten and intimidate people. They assert that they've invested millions of dollars into Meg in her career, and she is contractually obligated to perform. However, Meg doesn't feel that way and says that the contract is unconscionable, and we're going to get into that. So, what makes a contract enforceable? A contract is enforceable when it has mutual assent, which is an acceptance and an offer, mostly the offer first and then an acceptance. Consideration, which is a bargain for exchange of something of legal value or a substitute for consideration, such as promissory estoppel, detrimental reliance, or a good faith modification under the UCC. It also means that there's no defense, meaning there's no mistakes, no illegalities, and it doesn't go against the statute of fraud. So one of the claims on Meg's petition is that her contract is unenforceable. When we look at a Hofelden approach of this, Meg signed this contract, and when she signed that contract, she entered into a right-duty relationship, meaning that she had a duty to perform at that time. However, now she wants to renegotiate that deal, and that means she wants to enter into a privileged liability relationship. This is not easy to do once you are in the performance of a contract, which is why this is sort of a I don't want to say unique situation, but it is definitely something that we see in contracts. When contracts are wrong, you have to have a very, very good argument as to why you can't do this. So we have an offer, we have an acceptance, we have consideration, which was she got all these things, and here we go. We have no defense. So let's get into the lawsuit details. The lawsuit details says that she was fraudulently induced to enter the contract and that the contract is unconscionable and therefore unenforceable. That is very important to take note of. Unconscionability is something that we talk about in contracts a lot, and this is something that we are actually going to get into for her case because it means that some things were unfair. As for the fraudulently induced, we're talking about undue influence. So let's get into unconscionability. So let's look at unconscionability. To be unconscionable means that there's extreme unfairness. It means that the contractual terms unreasonably favored the other party. And when an element of unconscionability exists in the contract or when the contract is formed, it means the contract is unenforceable. And these circumstances include gross inequities of bargaining power as well as the manner that the contract was entered. So the terms of the contract must be considered in light of the general commercial background and the commercial needs of the particular trade of the case. So the thing is, Meg's contract does not meet industry standards. So much so that her label is getting much more than what a typical label would get. This reminds us of a few situations, namely Williams versus Walker Thomas Furniture. So Meg is saying that, you know what, I didn't know anything about the industry. I thought this was going to be a very typical industry contract, but I was very much so unaware that they were going to be in my business when it comes to sponsorships and merchandising and everything else. I didn't see those terms. I didn't understand those terms. When we look at Williams versus Walker Thomas Furniture, remember, Miss Williams was making a payment on all of her furniture. She missed one payment and they tried to take all of her furniture back. This is essentially something that the appellate court saw as unconscionable and saying that the trial court missed and sent it back down. Meg is saying, hey, they're taking all this money from me and I'm paying all these people, and I had no idea that this was even in my contract. Had I known this was going to be a part of my contract, I would not have signed it. This is not an industry standard. And we'll get into the terms of that contract next and how they are not industry standard. Typically, an artist has a majority. So keep that in mind when we go through the terms of this contract. So basically, that's the unconscionability of the contract. And when a contract has unconscionability, that means that it is unenforceable. So let's look at this contract. A big part of recording artists' contract always comes down to who owns the masters. In the contract that Meg has with 1501 Entertainment that was signed back in March of 2018, she does not own her masters, which means that 1501 has the right to use, produce, and distribute her music as they please because they own it. This is not good. Most artists negotiate their contracts in a way that helps them retain their masters. This is one of the things that Meg says that she did not know when she signed this contract. She claims that she thought she was sharing, quote unquote, her masters, which I can kind of see that is a little bit of the industry standard, but she doesn't. They own her masters completely, and she has given them full exercise of the power of her music. The next thing is royalties. Royalties are the payments made to artists for their artistry. Most companies and labels take a portion that, in a good contract, leaves the artist with the majority. This contract states that unfortunately, Meg is only going to get 40% of her royalties. Now, the issue with that also is if you read the contract, it says that she gets her royalties after they pay engineers, producers, backup singers, so on and so forth, people to help mix and master it. So she's paying all those people out of her 40%. That is terrible. No one wants to pay additional personnel out of their cut. This is another element that she says that she was unaware of when she made this contract. So that greatly reduces her share of her royalties. So she's saying she's only getting about 15%. Live gigs and performances and other side projects. So this was a very interesting portion of her contract. According to this, it says that all net proceeds over $1,000, she will get 30% of. 70% of that is going to 1501 Certified Entertainment. Now, the real crazy part about this is it says that she understands and acknowledges that the label is allowed to recoup all tour support costs incurs, quote, off top, meaning that anybody from setting up the mics to feature artists, all of that is coming out of her 30% off of the top. So she's also getting more deductions out of her share, which is something she also says she had no idea about. That is a very bad part of the contract. And even her side engagements, they're taking 70% of. So let's talk about merchandising, sponsorships, and endorsement rights. Every artist, especially if you have a huge social media following, you want to make money in merchandising and sponsorships. Megan currently has deals with Bitcoin, Cash App, Popeyes. I tried the chicken sandwich. It was actually quite bomb. Nike, and one of my favorite shows, which is HBO's Legendary. She is a judge. What are they taking? 70%, leaving her with 30%. Fortunately, there's no hidden things in this part where they're taking more money or anything like that, but they're getting 70% of the net proceeds, and that actually comes through them. Again, she says she had no idea this was in her contract at all, and that is what's making it unconscionable and unenforceable. So let's look at what the court documents say. So one of the things that she is claiming is undue influence. If we look at the restatement second, it says when undue influence makes a contract voidable, if a party's manifestation of a sense is induced by undue influence by the other party, the contract is voidable by the victim. So her claim of undue influence actually goes back to when the contract was initially formed. She did not negotiate her contract. Her mother negotiated her contract. Her mother at the time was suffering, unfortunately, from brain cancer. And Meg said several times that she just wanted her mom to stop working. I sympathized greatly with that. Um, so she took the money. They gave her $10,000 to take the money, and she needed the money, and she signed it so she could help her mother. And she's been stuck in this contract since 2018. Of course, since 2018, she's also won three Grammys and made millions and millions of dollars, most of which is going to this label. Now, what do they say in the defense of this? Well, they're using the restatement second, section 177, subsection 3. It says if a party to the transaction, the contract is voidable by the victim unless the other party to the transaction, in good faith and without reason to know undue influence, either gives value or relies materially on the transaction. The funny part about this is T. Ferris is the person who negotiated the contract. Carl Crawford told Meg that if she wanted to be mad at anyone, be mad at T. Ferris. Carl Crawford claims that he didn't even draft this contract. He's new to the game. He didn't know anything about it. His first time running a label. So he didn't even know the terms of this contract. That's quite funny because that is actually one of the defenses that could be used. And it's a good defense to use because what he's saying is, hey, I didn't make this contract to hurt you because I didn't make this contract at all. So all of these things are surprise. Doesn't work that way, guys. Okay, let's talk about tortious interference. So tortious interference is something that we don't really talk about in contracts, but I wanted to bring it up because it is one of the main aspects of her claim. So tortious interference with prospective advantage is an intentional damaging intrusion on another potential business relationship, such as the opportunity to gain more employment. And it's also termed intentional interference with prospective economic advantage. So, all that legalese, what does it mean? Okay, what it basically means is that 1501 Certified Entertainment is blocking my money. And how are they blocking her money? So, she signed a deal with Rock Nation, which is Beyonce's husband's label. I always say Beyonce's husband because I love Beyonce, but it's Jay-Z, international superstar, hip hop legend, right? He has Rock Nation management. Now, why does she have to sign with them? Because her mother regrettably and unfortunately passed away from brain cancer, which deeply affected her. Her mother ran all of her business. So she went to Rock Nation. That was also with T. Ferris. And what did they do? Well, Carl Crawford got upset, started blocking all of her music. She had songs that were set to be released. She also had an album named Sugar, which has come out. That was also set to be released, and they blocked it. Because she filed this suit against them, she was able to get a restraining order that allowed her to release music. And that is how all of that got done. But what they were saying, or what her claim is without the interference of the court, I'm not going to be able to make money. I am going to lose out on potential business relationships. My fans are going to suffer, my fan base is going to suffer, and therefore economically I'm going to suffer. So what is the defense strategy? The defense strategy is actually very smart. It is look at the contract. Of course, it's look at the contract. That's always the answer, right? So they say look at the contract. When she signed this contract, she signed a major label slash distributor clause. What that means is she gave 1501 the power to sign her to a distributor, which is exactly what they did. They signed with 300 Entertainment, which is another independent label slash distributor, and they can work, quote, on behalf of the artist and control when her albums and songs can be released. So they got upset. They blocked it. One of the reasons they're saying they blocked it is because they stopped getting money. When she signed to Rock Nation, they started having this reviewed. All of her contracts were getting reviewed by, quote, real lawyers. That was her words, not mine. And they discovered all these things and she wanted to renegotiate. But she also wanted her music to continue to flow. They said, no way. We're not going to do it. We control your distributor. We can control when your music. We actually technically own your music. And therefore, you are under our thumb, so to speak, until we tell you to. And we'll get into what the terms of the contracts are later, but that's one of their defense strategies. We do it because we can do it, which honestly, I guess that's okay, but not when you have unconscionability on the table. Another defense strategy is we can extend your contract, so we did. Now, this part of the contract is actually a bit confusing to me. It basically says that initial period is 12 months from the full execution date of the agreement. So that would have been somewhere around March of 2019. But the company also has two separate consecutive options to extend the term period, which is called an option period. And there's all of this legal jargon about the option periods, if any are referred to as contract periods, and basically they have all this power to extend it. And there's some language about her giving them, a 30-day warning. But the issue is I could not find what an option period would it be. I assume this is also what Meg had a difficult time understanding. So they're saying, hey, your contract is not expired because we've exercised this power, without giving a date. And they actually did not give a date until the arbitration agreement that was just signed in October 6th of this year. So that was a little bit of a sticky situation. So let's talk about why any of this matters. So what this is called is a 360 deal. So that means that this label has their hands in every single thing. And because they have their hands in every single thing, she basically gives them a majority of her money. She's been giving them her money, and the money's been flowing through the label with no accounting. This matters because when you have a contract that is unconscionable, when you sign a contract that has terms that you don't understand, you can find yourself in a very sticky situation and a damaging situation. And that's a problem because when we make contracts for a benefit or a detriment. This contract was supposed to be a benefit for Megan, and she didn't get it. A bigger issue is that the defense's argument about this is, hey, the contract is enforceable, and therefore you have to deal with it. Now, I actually had to add this slide this morning and completely re-record this because there was a development. So there is an arbitration agreement that has a big Texas-sized stamp on it that we can't see. But thanks to the defendants writing a response to Meg's motion to compel answers regarding an accounting, we know that there was an arbitration agreement that was signed on October the 6th. And in that arbitration agreement, she has to give them 2 albums before she's out of her contract. So what did she do? Well, she figured out they own my masters. I am going to release all of my archives. And these archives are freestyles, which I love. Meg freestyles. Because I was a fan of hers way before this. So she just released all of her freestyles because they already own them and they own the outtakes and everything. So she's going to find every way to get out of this contract now that she's signed this arbitration agreement. So she very well could be on her way out of this contract within the next year or so. So I just added this as food for thought. because she entered this contract when she was young and inexperienced, and she was a normal person who wanted a music career, who wanted to help her mother and felt pressure to do so. Now that she's a celebrity, can she use that power to renegotiate, and is that her right to do so? My answer is absolutely. There's an arbitration agreement in the clause just in case this happens, and I think she's in every right to exercise her ability to renegotiate. So I love this question. What would Beyonce do? Meg is doing exactly what Beyonce would do. She would renegotiate. She would try to get the best deal. She would go back to the table and say, hey, you took advantage of me when I was in a very difficult situation, about to lose the person that I love more than anything in the world. Her mother took care of her and put her first in every situation. She was a single parent. And she is not the first person to get herself in a situation with unconscionability and unenforceable contracts. To put it plainly, if you have a contract that has terms that you do not understand, you need to renegotiate it. We look at it with the Quicken Loans versus Brown when they had bad refinancing terms, Capelli and Finish Line, Bauer and Gateway, William and Walker Thomas Furniture. You just should not have terms in your contract that you did not understand. This is the legal stuff. Don't sue your girl. This is for educational purposes and is not legal advice. My name is Dominique Alford. I'm a Juris Doctor candidate at Stetson University College of Law, where I'm a 1L student. Thank you, Professor Jimenez, for supporting my crazy projects on someone who I love. And from one hot girl to another, keep it real, guys, and please read your contracts.